Hello, everyone, and welcome to a conversation about regulation and technological innovation. I'm Adam White, and I direct the Boyden Gray Center for the Study of the Administrative State. It's my pleasure to welcome you and to welcome our featured guest, Commissioner Noah Phillips of the Federal Trade Commission. He was appointed to the Commission in 2018 after a career in private practice and government service as Chief Counsel to Senator John Cornyn of the Senate Judiciary Committee. Hello, Commissioner.
Hey, Adam, how are you?
Good. Thanks a lot for joining us today. Just by way of background for the audience, this was originally intended to serve as a keynote address at a conference we had scheduled in March. The Gray Center last year hosted a private research roundtable where scholars workshopped some new papers on various aspects of technology and regulation. We were going to have a live conference to present those papers in March and then a keynote address from Commissioner Phillips. Needless to say, live conferences weren't a thing anymore in March. Now, I will say, in addition to this webinar, we've been taping podcast conversations with the authors of these papers. And so soon we'll release those conversations in a series and then also the audio from today's conversation. So, Commissioner, I'm glad we're finally getting to have this conversation.
Me too. And in part, thanks to technology.
That's right. That's right. Well, let's jump right in. When I teach administrative law at Scalia Law School, the FTC often serves as an example of what happens when an agency gets criticized by Congress for having done too much. These days, if anything, it seems like the FTC gets criticized for not doing enough. How would you characterize the FTC's role today?
So let me begin by sort of giving the caveat that someone in my position always has to give, which is the answers that I give are just mine, not necessarily those of the agency or my colleagues. You know, I think the agency today exists in a really interesting place. We enforce a number of specific statutes that Congress has passed over the years, but in the main, the FTC Act, our organic statute, which is a pretty broad statute. Now, I'm sure you teach in your administrative class that breadth has been to some extent circumscribed by Congress over the years because of concerns about agency overreach. But the breadth of the statute allows us to target conduct that tends to occur throughout time, despite changing conditions in the economy and despite technological development, and across the development of those technologies, and even bring within our ambit issues that would never have been contemplated at the time the statutes were drafted. So a very good example of this would be data security. The FTC moved into the data security space, and there was litigation over this question, in particular in the Wyndham case. And won decisions in federal courts ratifying the notion that the deceptions that we could reach under our deception authority, or the unfairness that we could reach under our unfairness authority, could apply to novel technological contexts. And we live in a world of rapid innovation, where there are all sorts of new and innovative technologies that raise a whole boatload of new and innovative risks and threats, and the law can be brought to bear. And that's a big part of what we do.
In remarks you delivered at the National Press Club in early March on technological innovation and the digital marketplace, you set the scene by referring to what you called the FTC's somewhat convoluted history. Namely, in the 1910s, the FTC was created to promote competitive markets, and it was given powers and responsibilities to that effect. Then a couple of decades later, in the 1930s, its mission was expanded to include consumer protection more directly and more specifically with unfair and deceptive acts and practices. How do those statutory mandates and the FTC's other responsibilities shape your work and the way you look at your work in these times of technological change?
So a little bit of the backstory. After the agency was created in 1915, when we were created to find, unfair methods of competition in the market, to study and then go after them under our statute, some of the conduct at which we began to look in the ensuing years and decades looked a lot like what we would call today consumer protection work. And in particular, it was deception, right? So firms that were out there in the market, polluting the market with lies or other deceptive statements, whether deliberate or otherwise. And the courts pushed back on that. And so in I think it's 36, there's the Raladam case, where we go up on a deception theory and we claim it's an unfair method of competition, that you were deceiving customers and so you got a leg up in a way that your competitors didn't. And the court said what courts today would say all the time, that isn't in and of itself a competition problem. You need to show competitive effects. And Congress responded. They responded by giving us what we now call UDAP authority. That's unfair and deceptive acts and practices authority. And it's the UDAP authority principally upon which Congress has built over the years, into privacy, into credit reporting, into a whole host of different things where it's firms, in particular firms facing consumers. We just did a negative option case that came out today under ROSCA, the Restoring Online Shoppers Confidence Act. That's like yet another congressional example of building on what we now understand to be consumer protection. You do see, in particular, in the statements of Commissioner Chopra, you see it in some of the ideas coming out of Europe, attempts to sort of bring together those concepts to treat what we now think of as consumer protection cases also as competition cases. My general view is, Congress passed two different statutes and they had in mind two different things, and we ought to think about them in two different ways. Often the two align, but sometimes, in particular, depending on the kind of consumer protection that you're doing or antitrust that you're doing, they can be in tension. And so I think it's helpful to sort of think about what is the law that we're executing here and stick to that.
That's an interesting point. I guess it's very important, isn't it? That even though you have all these mandates that you've been given by Congress and tools at your disposal to pursue those, and they often move in the same direction. I was just thinking, competitive markets and good information. I mean, you often you talk about competitive markets and consumers' access to good information, right? Those are ideally one and the same thing, right? Good information promotes competitive markets. But at the end of the day, you're given a set of statutes that you need to enforce. And so you need to be very, very careful about which statute is at issue in a given controversy.
Oh, yeah. Right. I mean, so take as an example, with the Sherman Act presumably very much in mind, Congress in 38 gives us consumer protection authority. They don't, for instance, do treble damages, right? There are aspects of antitrust law that just don't apply. And Congress makes certain judgments about the tools at the disposal of enforcers, whether criminal tools or in our case, civil tools or, private actors in terms of private rights of action. And I think we need to recognize those judgments and limit ourselves where appropriate.
Now, these are all timeless issues. Your agency is more than a century old. It's been grappling with these issues for decades upon decades. Is there anything different about what's happening right now? You focused lately, you gave remarks about a year ago about discussing, and here's a quote, evolving technologies, automation, and intellectual property issues can increase the complexity of your antitrust investigations and litigation. I mean, I guess in some ways that's always been the case. There's always innovations. There's always new technology. Is there anything different right now about the moment for the FTC that sort of changed either the political or practical context in which you're doing your work?
I do think that new technologies are getting a lot of political attention. And the ramifications that those technologies create. I'll pick on privacy. So I worked for 7 years on Capitol Hill, and we talked about privacy. And in particular, the privacy about which we talked, because these were the years that included the Snowden leaks, was government access to data collected about people. I think that the attention being paid to consumer privacy, although it existed then, is much greater today. I think there is better understanding of the kinds of data being collected about people, and greater concern about some of the ramifications of that collection, whether it's just the amount of information, the capacity to assimilate that information, to utilize that information, whether for advertising or other purposes, concern about breaches, right? As we collect more and more data, and I don't even know what the words were at, terabytes or petabytes, or they keep creating words because the volume of data increases hyperbolically. The threat of what a data breach can do on some level grows. That's one of the reasons I think we need a federal data security statute. I think there's a market problem that we need to rectify. And I was talking to the Senate about that in testimony a couple of weeks ago. But I think with all of the many opportunities and technologies that all of us take advantage of, that we're taking advantage of right now, have come certain risks. And I think people are becoming more aware of what's going on. And there's a debate about what concerns the law ought to address, the harms are. And I think that's a healthy debate. One of the interesting things about where we stand in that debate as an agency is that because of what I was saying before, the breadth of the statute and the fact that deception is one of those timeless market failures. It's something firms have engaged in since probably before, well, I wouldn't call them firms, but since before we had written law. And unfairness similarly is pretty broad in the way that it's drafted. And that's explicitly having in mind the fact that Congress may not have ex ante been able to anticipate all of the things, all of the ills it wanted to cure. And so I think in keeping with that statutory mandate, we will move into new fields and look at new things and try to address it best we can.
We'll get back to the breadth of these statutes in a bit, but for now, let's just stick with the technology question. With all due respect, Commissioner, federal agencies are not usually at the front end of the curve on technological developments, right? You're in a constant game of catch up. How can a commission like the FTC keep up with technological innovation, both so that it's mindful of what exactly it's regulating and also mindful of what issues might be coming over the horizon that might need a new regulatory look?
So, I think there's a number of ways to do that best. We have special authority to gather information from the market. That's our 6B authority. It's something we've had since the beginning. But we spend a lot of time talking to not only participants in industries, of businesses themselves, but people who monitor them, consumer groups, folks on Capitol Hill also always have a lot of input, into what we're looking at. And I don't entirely, I agree that technology will develop quicker than government is always able to meet it. I think that's just something we've seen that is true over time. But we do have pretty smart people, and I think there are times when we are ahead of at least, the curve of the op-ed pages and members of Congress in terms of what we're targeting. I'll take as an example, it's very much in the news today, but we sued a company called Musical.ly, which was sold to ByteDance and is now known as TikTok, and got them under order quite some time ago, probably about 1.5 years ago. I might have the date a little bit off. At the time, I had not heard of TikTok, but the people we have working for us had. Now, my then 7-year-old also had, so maybe we ought to have a committee of youngsters to help us spot trends. But there are a lot of times where I think we do a pretty good job at that. That said, technology is always going to be ahead.
I don't know if you've heard, but TikTok is back in the news in case you haven't heard. I just wanted to throw that out there.
I remember being on a panel at the IAPP, which is like a privacy lawyers group, I think 1.5 years ago, and it was sort of me and the head of the French privacy authority, the CNIL, and it was a moderated thing. And we had just done the TikTok case, and I brought this up, and she sort of said, well, that's something we ought to look at. And lo, right, it's in the news now that they're taking a look as well. But I think, look, keeping current on what people are doing online, keeping current on what the Academy is putting out, having technologists on board to help translate into law what we're looking at, all of that is, I think, really important. The one thing I will add, though, is some of the bad conduct that we deal with, in particular under our deception authority, is conduct that is of a species that has existed for a long time. So people are deceiving about one thing, they're deceiving about a new thing. The technological context is different. The firms may be, or what their business conduct may be more difficult to understand, but the underlying wrong is often very similar.
Before we turn to the next question, by the way, I just want to remind our audience that there will be some time for Q&A after I get through my questions. And so if you would like to ask a question, just use the Q&A function in the Zoom platform. We're not going to use the hand-raising function, but just type your question in, and I'll get through as many questions as I can with the Commissioner. A moment ago, you referred to your broad statutory authorities. I mean, that raises some pretty fundamental questions in terms of constitutional governance and separation of powers. The perennial question of the non-delegation doctrine, which of course the FTC has had to grapple with now for nearly a century. This is something you actually brought up in one of your recent speeches, the Supreme Court's decision in Gundy, one of the recent non-delegation cases. To what extent do you and your team, or the Commission in general, have to grapple with those sorts of constitutional issues, especially the non-delegation doctrine, as you're going through the work of applying these statutes?
In the main, when it comes to regulation, right, to which the non-delegation doctrine applies, and it's worthy of note that the FTC, most of what we do is what I think what we talk about as, and a lot of people would consider to be law enforcement. So we're enforcing the laws on the book. And the non-delegation doctrine doesn't really arise in that sort of case-by-case look at various conduct. When it comes to rulemaking, however, I think it's a more difficult issue. And what struck me, if you go back and you read Schechter-Poultry, which is one of our canonical non-delegation cases, the proposal under the NIRA is that the president be able to promulgate codes of fair competition. And in looking at the question, the court contrasts the FTC's statute. Unfair methods of competition, which are sort of, this is like a converse in terms of the linguistics of the thing. But at the time, no one is thinking about, and the FTC won't start thinking about for half a century, the notion that you could make rules about it. So the remarks that I gave were in the context of our consideration for the first time, I think since the 1960s, of making rules about unfair methods of competition. The old story of the agency has to do with UDAP rules, right? Unfair and deceptive acts and practices. And then we kind of got ahead of our skis and Congress passed the Magnuson-Moss Act. So it's harder to make consumer protection rules. There was a period where the agency took the position that its authority to make rules to effectuate its jurisdiction under the statute also governed substantive rules of the economy. And the DC Circuit ratified this. We only ever made, to my knowledge, one competition rule. But the proposal that we were considering when I made these remarks was to do another competition rule. And I do think you have to wonder if the words say unfair methods of competition, what does that mean? And if it doesn't have a fixed meaning, then does this raise a non-delegation issue? And I think there are some really interesting words that Justice Gorsuch wrote about what unfair methods of competition meant when they were distinguished by the Schechter-Poultry Court. And I think you have to ask the question, is a rulemaking that we would undertake within the scope of that language today?
And needless to say, that Justice Gorsuch's opinion in Gundy is it's the dissent that launched 1,000 law review articles, and everybody's writing about non-delegation now. The Gray Center workshopped a number of non-delegation papers this spring that will be coming out soon. But in terms of your own remarks on this, since we brought it up, I want, if the audience is curious, I have in mind at least the remarks that you gave on January 9th on non-compete clauses in the workplace. examining antitrust and consumer protection issues. So full remarks are available online if people want to look them up. It is funny, the statute that you referred to, these unfair and deceptive acts and practices, I mean, you look into the history of this, I mean, those are very, very old concepts going back to long before there was even an FTC. I think one of the challenges for the FTC is taking these old statutes and trying to figure out to what extent are we really hemmed in by those, I mean, sort of in a way prehistoric meanings, and to what extent are they, you know, open-ended either invitations or mandates to really think about unfair and deceptive acts and practices in new and innovative ways.
Yeah, and we've gotten some guidance from Congress on unfairness, but on the antitrust side of the house, in terms of the unfair methods of competition, there is consensus that that goes beyond the scope of the Sherman Act, the Clayton Act. And there is a policy statement that we have about how far beyond it goes, but there is a great deal of debate how far beyond it goes.
Now, speaking of Congress, one of the constant pressures that a commission like yours faces is calls for either new rulemaking or other new forms of policy making on issues where people could go to Congress and ask for a statute to either be written anew or refreshed and reformed to more explicitly tackle these issues. About a year ago, you had a Wall Street Journal op-ed regarding the FTC's investigation of Facebook. And you mentioned along the way that, quote, the FTC is a law enforcement agency, not a legislature. Why don't you describe that dynamic that the FTC faces and what you mean by that? What's the difference between the FTC being a law enforcement agency and not a legislature?
Sure. Let me expand on what I meant and maybe build out from that. So the particular context of the op-ed, at this point in the op-ed, what I'm saying is that I expect a lot of people will not be satisfied with the results of the Facebook investigation, in part because it fails to address lots of issues they have with Facebook. And I go through a litany of issues that people have brought up with respect to Facebook. And I'll pick on one by way of example. So there are people who really object to behavioral advertising. That is advertising that is targeted at a person based on their conduct online, what websites you visit, what you look at, for how long you look at what you look at, these kinds of data about you. And that's a fair debate. I think we ought to have that debate. I think it's part of the debate we are having. But Facebook didn't break the law in having that as part of its business practice. We didn't allege that that broke the law. And there were calls that we should end their practice of using behavioral advertising. And my view was, if they weren't breaking the law and it wasn't part of what they were doing to break the law, and it was legal, we didn't have a lot of role in addressing it. Now, sometimes we engage in what we call fencing in relief. So, you know, there are fraudsters out there who are engaged in certain kinds of conduct. And we not only ban them from the particular illegality, but we ban them from the kind of conduct that will keep them away from the illegality. I think when you're getting into conduct that is endemic in the economy, when you're getting into conduct that is legal, you have to be very careful about making it illegal by yourself. And this is a great example now, I think, because Congress is considering whether to adopt a privacy law, like a generalized commercial privacy law. And my message to them has been consistently, you shouldn't give us broad rulemaking authority. There are important value judgments that you need to make that we are less well equipped to make. We're not a legislature. We're not as responsive to the voters. And ultimately, there are trade-offs that are going to need to be made, which really aren't a matter of expertise or anything you would normally think of as, you know, vesting in an administrative agency. They're just value judgments, and they're fair. But how we land is the kind of judgment better suited at the end of the day to Congress.
We'll jump ahead to a question I thought we'd get to later, but also earlier this spring in late January, you gave remarks that were titled before, I guess it was at Stanford Law School at their Center for Internet and Society. You gave remarks titled, "Should we block this merger? Some thoughts on converging antitrust and privacy." And again, these remarks, like your others, are available online. Could you describe that debate and why you're wary of what you said is the convergence of antitrust and privacy regulation?
So the debate is not new. Pamela Jones-Harbor, who was an FTC commissioner long before I got on the commission, brought this up some time ago. But you've heard out of Brussels and other capitals in Europe a real drumbeat to try to merge privacy and competition law. There are, arguments, some of which are better than others.
Real quick. What could you explain that? What do you mean by merging? Are those are two areas of law that are distinct now, and what does it mean to merge them?
So people are a little less clear on what they mean, but they often talk about merger, and there have been conferences devoted to this question. I think this concept, in terms of its real application, finds its best expression in a case recently decided by the German Supreme Court, where I'm going to simplify a little, but in essence, the Bundeskartellamt, which is the German competition authority, argued that a GDPR violation was also an antitrust violation. It was a form of abuse of dominance, which is a concept under Section 102 of the EU treaty. The other place that you see this come up, and Pamela Jones-Harbor gave voice to it in the US, you see it coming out of the European Commission from time to time. There will be a merger of two companies, both of which will sit on a lot of data about people. And so someone will bring up, should we also look at the privacy implications? My view is privacy isn't irrelevant to competitive analysis. You can have firms competing on privacy, and you could have a transaction or practice that lessened privacy, just like it raised price or decreased some other aspect of quality. But privacy makes this a little bit complicated as a question for a number of reasons. Two reasons that I'll pick on. The first is that consumer taste for privacy is pretty varied. People experience different marketplace conduct differently. And that's not like price, right? Everybody wants lower prices. So it makes the analysis harder. And distinguishing an exercise of market power from product differentiation can be difficult. That's something your colleague James Cooper has written about. The other thing that strikes me is that it's not hard to find examples of where these two concepts, not always, but can be in tension. So at the end of the day, consumer data privacy is mostly about limiting access to data. And access to data can be competitively relevant. It can be important for folks to have access. So you could imagine, I don't think they would be very popular, but you could imagine a network, a platform or whatever that gathered a lot of data about you and gave it to everyone. And that would stoke a lot of innovation, but it wouldn't be good for privacy. There's a case that came before us where the circumstances that I'm about to describe aren't the case itself, but they kind of happen around the case. The company is called Unroll.me, and they help you manage your Gmail account. And the way that the way that they're in business is they search your account for receipts, which they supply to Rakuten, which is a market intelligence firm. And around the time that we were looking at the firm, and I wrote about this publicly, Google decided to shut down third-party access to the contents of Gmail. Now, it seems pretty clear to me that that is a pro-privacy move, right? The contents of your email are obviously something that a privacy interest would contemplate. But here was an example of a company that was using that. And so it's not clear, and it may very well be negative, what effect that pro-privacy move had on competition. And I think there are aspects of this all over, right? So look at the back and forth over the rollout of iOS 14, right? The new Apple operating system for the iPhone, where they're going to push to you a choice of how your data is collected by apps on the phone. That's a very good example of where you see these two in tension. And the fact that they are sometimes in tension, not always, but sometimes, I think makes this a very odd place to call for merging two areas of law.
I have to say, on this issue, the iOS 14, I'm a regular reader of Ben Thompson's Stratechery newsletter,
Which is terrific.
It is terrific. He there, and here's some plugs for Ben Thompson and his podcast called Dithering. He and John Gruber have been talking on and on about just how to think about things like the App Store and ways in which the App Store might be pro-consumer or anti-consumer. It's incredibly hard to unpack. I suppose I just listen to these for information. Pity the poor commissioners who actually have to think about it for how they're going to regulate. That's not a question. I won't put you on the spot about it. But or you're about to say something? No.
No.
It is just fascinating to watch this play out, and industry in a way has its own role to play, not just as market participants, but also as forms of self-regulation, right? We have things called agency or industry best practices, right? The industry's in a way kind of regulating itself, sometimes harder, sometimes softer, but trying to do the best it can. Now there's bad versions of that. Again, Schechter Poultry in a way was sort of industry best practices elevated to the form of regulation itself, right? You do need government to be the regulator at times, and not just sort of delegate that power out to industry. But how do you see the role of industry best practices, industry self-regulation, that sort of thing, as maybe private solutions to some of the otherwise anti-competitive or otherwise negative things that would come before the agency?
I think fundamentally it's a positive. You gave, with the Schechter Poultry example, one very clear way where it can go all kinds of wrong, which is that industry takes the levers of power of the government, right? They take the force of law and then they use it. And this has been a leitmotif in FTC enforcement over decades, right? Looking at licensing schemes in states in particular. And we went up in North Carolina Dental to the Supreme Court on this question, kind of fighting the state action doctrine where it's used really just to empower industry players to police themselves. That's a bad version of it. But I do think that there is absolutely a role for industry best practices and self-regulation to augment the work the government does. And I will tell you, if you take an example of the Better Business Bureau's CARU, which regards children, that's helpful in enforcing COPPA, the Children's Online Privacy Protection Act. They help alert us to things we ought to look at. Same thing for advertising. So there are a lot of these industry groups that do serve a really important role in augmenting the function of government, and maybe even without the heavy hand of regulation, achieving, helping to stop some of the market problems and achieving some of those benefits for consumers.
Now, we do have some audience questions, and I'll turn to those now. I'll remind people, if anybody else would like to ask questions, go ahead and put them into the Q&A. And I'm so happy that our first two questions actually come from one of the keenest minds of administrative law and process in all of Washington. It's Jeff Lubbers from American University's Law School. Here's his first question. Commissioner, given your experience on the commission, how do you feel about the pros and cons of multi-member independent agency models, especially for regulating new technologies? And I'll just add, of course, this sort of has been put back into the spotlight by the Supreme Court's decision in the CFPB case, Sealy Law versus CFPB, where they really limited agency independence by and large to multi-member commissions, sort of extolling in a way the multi-member structure. How do you think about that? And again, with an eye to regulating new technologies.
I do think it has a virtue, right? I mean, you've got 5 sets of ears and 5 sets of eyes instead of 1. There are issues in which commissioners will take particular interests and they can socialize that among their peers. You've got, in the case of the FTC, when fully staffed, which we are, 5 different eyes looking at cases, spotting problems. Not everyone agrees all the time. We have a lot of dissenting. Sometimes I'm dissenting. More often some of my colleagues are. And that's, like all groups of people that have disagreements, it can be frustrating, but I think fundamentally it is a healthy thing. I think it helps draw our attention in good ways, and I think it helps hone our arguments, right? The drafts that you see come out, even when they're dueling, they go back and forth, right? And well, they really got the better of me in that argument, so I'm going to take it out. Or I need to address that point because that can't be left alone, it's a valid point and it needs an answer. So, fundamentally, like, it's a fun dynamic, and I think it's a healthy dynamic. I think it adds a lot of accountability in terms of what we are doing and the decision-making process. There are costs and benefits to that, but I think net, it's a good thing.
So I suppose the cost comes in terms of slowing things down, right? Alexander Hamilton's, executive in Federal 70 is energetic because there's just one president. He can move quickly. You all have to.
Article 2 is pretty clear on that.
Right. So, but for an agency like yours, the deliberative process that in many ways improves its work, it does come at the cost of slowing things down, or does it not slow things down?
I think it does on some level.
Yeah.
But I do think that having checks is helpful, especially when you're talking about broadly applicable statutes, which on some level is very much part of the statutory design, and even after what Congress has done, still is with us today. And so I think that, with great power comes great responsibility, and I think that is a helpful dynamic.
Okay, and then the second question from Professor Lovers is this. It's focused not on the structure of the agency, but its processes. He writes, the normal APA rulemaking process is a time-consuming process, but the FTC must use an even more cumbersome version of rulemaking under the Magnuson-Moss Act. So cumbersome, he adds, that the agency has all but abandoned any rulemaking under the Act. He asks, do you support reform that would allow the agency to follow normal APA rulemaking?
So we actually have ongoing rulemaking now. The negative option rulemaking is a MAG-MOS rulemaking, and we've used it from time to time over the years. It is more cumbersome, and I think that aspect makes sense in the context of potentially broad application. I think a lot of people didn't expect what the agency was up to in the late 60s and the 70s, and we went too far, and Congress put us where we ought to be. That said, we also have APA rulemaking authority in a variety of contexts. So COPPA, which I mentioned a moment ago, would be one of those. And I think it's a good mix. What I don't think you want is really broad rulemaking authority with fewer checks and balances. I think that's not the right equipoise, in our constitutional structure.
Let me just add a question of my own in this theme. The FTC has many tools and processes at its disposal, right? Adjudication and enforcement, rulemaking, investigations, and so on. With new technologies, cutting edge technologies, are certain processes sort of better than others? I mean, is there, for cutting edge technology versus, I mean, I don't mean to denigrate them, but sort of older, more sleepy or more familiar industries, does the change in technology really point you towards some tools more than others?
I don't think so. Resources and allocating them can be an issue. I mentioned before having technologists, and I think that's a priority around the commission to have people who focus in particular on, on areas at which we're looking. But, our subpoena powers, our enforcement powers, I think are specifically intended to, and if you look at the legislative history, I mean, this is the legislative history of the FTC Act, account for the fact that markets develop over time, and part of that development is technological.
Now, our third question, and after that, we have an open queue. So if any other audience members would like to ask questions, get them in now before we wrap. Ben Remley from Global Competition Review writes, does Commissioner Phillips have any thoughts on the Qualcomm ruling? I'll admit I'm not tracking these issues, so I don't actually know what the Qualcomm ruling is, but maybe it's familiar to you.
So the Qualcomm ruling, the FTC at the end of the Obama administration brought on a party line basis a case against Qualcomm. The particulars of this case require a lot of explanation, and I won't belabor this particular context here. The FTC won in the district court, and a few weeks ago we lost in the Ninth Circuit. How to proceed is still a question before the commission, so I don't want to comment on that in this context.
Just a couple last questions of my own. You're not the only agency that's involved in some of these issues, both in competition and other matters. You're either working along with or maybe bumping into other agencies. I'm just curious how the interagency coordination process works. I mean, just in very, very general terms.
So, as a commissioner, I don't spend really any time in the interagency process. I think there are some processes in which we are involved. The day-to-day interagency, to be honest, I'm not as clear about the role of the independent agencies within the day-to-day of what we often talk about of the interagency, right? So it's not like, Commerce and OD&I and Justice and Treasury showing up at a National Security Council meeting.
Okay, and then just one last question, and it's a very self-interested one. The Gray Center, like other programs like it, are in the business of helping to promote scholarship, helping to incubate scholarship, both on administrative law generally and focusing on particular themes or issues. Of course, again, that's how all this arose, was out of a roundtable that the Gray Center organized on regulation and technological innovation. From your perspective as a commissioner, how can scholars and researchers, what sort of work can they do to help inform the work that you do?
I mean, I think the work of the Gray Center has been terrific. I think there are a lot of really interesting issues going on with respect to privacy and competition in particular, in terms of thinking about what the proper agency structures are to address some of these issues, some of what we've been talking about today. So you hear calls, I think I read an article about this last week, for a new technology regulator, right? And that debate is happening in the context of legal development like SALA law, right? Where the courts are telling us what flies and what doesn't in terms of Congress's power to structure agencies. I think those questions are really interesting to study. You were talking about the sort of bevy of papers on non-delegation. I think people should look at the remarks that I gave. Unfair methods of competition rulemaking is a heck of a power. And there's already been discussion of it in Schechter Poultry and in Gundy, not with respect to rulemaking, by the way, just with respect to the meaning of the words. And I think looking more carefully at those questions is going to be a really important thing going forward.
We do have one last audience question. It comes from Chris Kane, who's a reporter at Accurus. He says, Commissioner Phillips, I expect that amid COVID-19, the political will and interest in curbing certain behaviors by big tech firms may lessen a bit. Consequently, do you anticipate any changes in how the FTC allocates resources going forward in the short and near term? Again, I'm not, I myself don't know what the premise of it is in terms of changing certain behaviors by tech firms, but do you have an answer to that?
Look, I'd say that tech firms remain a big focus for us, right? The chairman set up last year a task force to look at competition questions in the technology space, and that sort of matured into a formal division, what we call TED, the Technology Enforcement Division. We continue to look at mergers. The chairman put out a statement at the beginning of the crisis, which I very much agree with, which did say that where firms are, I'm going to get the wording wrong, but scrambling to provide needed goods and services to adjust to the effects of the crisis. I mean, the example I would give, although I don't want to put words in kids' mouth, would be a company providing an online education school to an online education tool to a school. If they're doing so in good faith, I don't think personally they ought to be the object of a lot of enforcement, but I don't think anything about COVID inoculates anyone from liability. I think at the end of the day, a lot of the behaviors that we saw before COVID we're seeing after, the big difference has to do with scams and frauds. But the technologies people are using are developing, right? They're probably hundreds of millions of Americans who are using Zoom today that weren't using Zoom 12 months ago. Fundamentally, though, I don't see a change in direction. I do want to allow for the fact that you might have, a company, again, trying to provide an online education tool, trips up on COPPA, but they're doing it in good faith. To me, that wouldn't be an.
Now, a moment ago, you said some kind words about the Gray Center. Obviously, I'm grateful for that. I enjoy this conversation about administrative process and structure generally. I do want our listeners to know, though, that on the substance of a lot of the issues that we've talked about, competition, privacy, and so on, the Scalia Law School has entire centers dedicated to those issues in particular, ranging from the Global Antitrust Institute, led by one of Commissioner Phillips's predecessors, then Commissioner, now Professor Josh Wright. And our Law and Economics Center has the program on economics and privacy, directed by the aforementioned James Cooper. So for folks looking for more information on the substance of a lot of these policies we've discussed, please be sure to check out those programs. Commissioner Phillips, thank you so much for joining us today. I really appreciate it.
Thanks for having me, Adam. This has been fun.
Great. And thanks to everybody for joining us today. In the months ahead, COVID-19 obviously will continue to limit our ability to convene events in person, which is unfortunate because one thing that we love to do is host all the conferences that we host each year. But in the meantime, we have plans for a variety of webinars and other events focused on new and timeless questions of administrative law, the administrative state, and constitutional government. We're also going to have a lot more podcasts. And again, as I mentioned, all of the papers that were originally written with an eye to a spring conference are being discussed in a series of podcasts that we will release soon. So if you don't already subscribe to our podcast and you're into that sort of thing, check out the Arbitrary and Capricious podcast on our website. And also keep an eye on our website for announcements and sign up for our email newsletter. Until next time, thanks for joining us at the Boyden Gray Center for the study of the administrative state.